Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer podcast. I'm your co-host, Thomas Vick, with the other co-host, Seth Wilson. Seth, how's it going today?
Thomas, I am doing great. It is a beautiful day for mid-July. The weather outside is about perfect. So it's a little hard actually to be inside working on stuff when you know things are so nice outside.
Yeah, it's a little bit better than it was the last couple days. I was just walking outside yesterday and I ended up in a full sweat just from being outside for a few minutes. It was quite hot yesterday. So, 70-degree weather in mid-July, you'll take that any day of the week in Indiana.
That's exactly right. That's exactly right. Well, I was excited to get a preview of your upcoming blog topics. And one of the things that I noticed or jumped off the page at me was talking about gifting to grandchildren and some of the implications that are involved in those decisions. And I know I don't have any grandkids, but my kids are grandkids, and we recently had the opportunity to celebrate my parents' 50th wedding anniversary,
Wow.
and so pretty neat to
Yeah.
see how that family has grown, and it's exponential, right? So there's each of us kids, and then they have kids, and just that grandchild explosion, so to speak. So it's pretty neat to see that. So that was kind of near and dear to my heart, and thought it might be a good topic for us to chat about today.
Well, you and I have that in common. My parents celebrated their 50th wedding anniversary this past December. So that topic was it fits well for both of us. So we're kind of in the middle with kids of our own. We got parents and, grandparents may be thinking about how can I provide for not just the next generation, but the generation after that. And you kind of think about the proverb, a wise man leaves an inheritance to his children's children. So that's really the topic today, and how to do that and the wisest way of doing that. You have a lot of different options, and two or three are mentioned in the blog digest, and we can kind of take them in order. But one of the main subjects of the topic was 529 plans. So 529 plans are savings plans for education. And the way that you can do it is you can set up a 529 with a financial advisor. You may not even need to have a financial advisor, but you can set it up, and your funds that are put in there grow tax-free. And when you take them out for educational purposes, then they're tax-free again. So it's just a great way of planning for a grandchild's education.
Yeah, I agree. Very important tool in there, and a related topic that could be considered is an educational savings account for the kids as well. And so you can look at both those types of plans and see which one best fits that scenario. But an awesome way to take advantage of some of that gifting. So that kind of leads to that question that is, well, how much can I put in each of these accounts on an annual basis?
Yeah. Well, the annual gift tax exclusion is $18,000 per year for gifting to any individual. So that's kind of where I would start on that. What do you have to say on the limits of that, Seth?
Well, it's always an interesting topic because you don't really think about it until you get into these discussions, because maybe you have 10 grandkids and you're thinking, well, how do I, navigate all of this? And do I have to give all of that? Or can I give more if maybe I have fewer grandchildren and I want to move some things around? And so being aware of the fact that any individual can gift up to that exclusion amount to any other individual in a particular year. And so if both grandpa and grandma want to write individual checks and take advantage of that exclusion, they can do so. And that's an important thing to keep in mind, especially if maybe there's a smaller number, or maybe the first grandchild is here, and you haven't gotten to the 13th, 14th, 15th grandchild yet, then you may be able to maximize that gift exclusion a little bit more. And all that really means is if you want to give in excess of that $18,000 number for 2024, you would need to claim that excess gift in a gift tax return at the end of the year, utilizing part of your lifetime exemption amount. And so that's where folks get a little bit confused about how all this goes through in my experience. And frankly, if I wasn't a lawyer doing this, I would be very confused by it all as well. So that limit on gifting thing, always kind of double check with your estate planning attorney and or your accountant for your particular situation as well, just to make sure that you're staying within those bounds and not maybe using up something that you shouldn't be using up. Now, saying that, we've talked about this several times, the lifetime exclusion amount is subject to change in the beginning of 2026. And so now may be a good time to start utilizing some of that and take advantage of those things too. So all the good things to talk about with your estate planning team. But as it relates to grandkids, kind of think about taking advantage of that $18,000 limit.
Yeah. So that was what you were asking about, the $18,000 limit. I thought you might have been talking about a limit on 529 contributions, and I said I'm not prepared for that question. But sort of on a limit to contributions, I know for the state of Indiana, there's either a tax deduction or a tax credit for contributions to a 529 account. And so that can lower your taxes from a state income tax standpoint for contributions to a 529 plan. And also related to that from an Indiana perspective, 529 accounts are not considered available resources for Medicaid purposes. So that can be a way in which you're not only helping out grandchildren, but you're also planning to protect assets for long-term care expenses. So those are a couple of nuggets that you can put in there as far as 529 plans are concerned. Not only is it great for your grandkids' taxes, it's good for your taxes. You get a tax deduction or a tax credit, and then also you can save when it comes to long-term care expenses by putting funds into a 529 account. As far as the gift tax or estate tax, yeah, I mean, you're right on it as far as the changing exclusion amount. That's going to be coming down at the end of next year. So that's an important thing to keep in mind as far as planning for your estate and for your grandchildren. One idea related to that, since it's possible that the exclusion amount is going to be coming down to more like $7 million, you might be thinking, well, should I set up an irrevocable trust in order to start the process of getting rid of those funds and kind of keeping them away from your taxable estate? And so that may be a possibility, something to think about with an irrevocable trust for your grandchildren.
Yeah. And it's a great point that there are contribution limits to different accounts and things to think through. But yeah, so that the trust thing, and we've talked about this on the podcast before, but what's really neat about it in the grandchild context is some of the protections and things that you can put in place if that grandchild is still a minor. And you can allocate certain types of restrictions on the use of those funds and what they can be used for. Or maybe you set something up to where you have just a common trust for the benefit of all of the class of grandchildren till the youngest one reaches a certain age. And so each of them is sort of provided with as much as you can do an equal share of the estate over time, or that share for them. Or you could set it up as separate shares for them as well, right? And so there's some things that you can do there. So what have you seen work well in your practice in terms of grandchildren type trusts?
Yeah, great question. I can think of a couple different examples of how I've designed trusts, but one way is, if the client is just ready to go ahead and establish a trust, the client could still be the grantor and the trustee of the trust, and the trustee or the trust could be revocable. So you could invest money inside this trust and it grows and grows. And as long as you don't touch it, you're not going to really get a whole lot of taxes on it. You'll have to pay on dividends and things like that. But when the grantor passes away, then you get step up in basis. And at that point in time, the beneficiary can begin to get principal distributions and income distributions from that. And maybe you set it up in such a way that at age 25, you distribute half, and at age 35, you distribute the rest of it. But I think that's kind of a neat thing, is to make sure you keep step up in basis in a trust that you kind of want to keep control of while you're living, but you also want to have it set aside for a particular child or particular children. And that's one way that you could kind of plan for grandchildren inheritance. So that's one way. And just kind of talking with the client about what's important to them. What do you want to provide some direction to the trustee about how these funds are going to be used? Do you want the funds to be used conservatively and only used if they really need it, or do you want it to be more liberal and kind of be the ultra generous grandparent? You can design a trust however you want it to be, really. And so those are some ideas that I've had in the past.
Yeah. And really that's where I see this in my practice. Is these are sort of funds that, if I was still able to be here at the time, the kind of replicate how I would do this during life. And so I want to make sure that the music lessons are covered, or the sports enrollment fees are covered, or the family vacation that we take every year is still available to everyone. And how I would direct my trustee to mimic what I would have done had I still been able to be here, until a certain time goes by. And there's certain levels of complexity that you can put into a trust in terms of its length and how long it will stay into play, and that changes over time. In Indiana, it gets extended over time. But then you also want to kind of take a holistic approach of, all right, we're tying up these funds, but do we tie them up forever? Well, probably violate the rule against perpetuity, so we can't do that. And then backing away from that, like, when do the folks who will benefit from these gifts be in the best position to use them and manage them, and how do we kind of balance those two concerns out so that we don't tie it up unnecessarily, or maybe subject it to unnecessary tax, being taxed at a higher trust rate than at an individual rate, and those kind of things. So like I said, when I talk to my clients about this, I said, well, this is where the lawyers get really excited, because we can draft up this amazingly complex plan, and it may be way too much. So it's got that balance between the two of making sure that it handles what we're trying to accomplish, which is be a good steward of those assets, without making it too hard to administer when it's time.
That's right. And you do have to find that balance between, all the bells and whistles that an attorney can put into a trust, and really just the simple purpose of the trust itself. And there's going to be somebody other than the attorney drafting it that is going to administer that trust. It's going to be an adult child, the grandchild's parent, perhaps, that's going to be administering the trust. And so you want it to be a document that is understandable to an individual, and kind of see how, specifically what that trustee is supposed to do. So you kind of want to keep that in mind as well. But yeah, there are just a ton of options for grandparents, and how to protect assets, and or just plan for handing inheritance down to, not the next generation, but the one after that.
Yeah.
And so those are neat discussions to have as an estate planning attorney. You get to kind of design a way to bless, the grandchildren, and that's really, really, fulfilling in my mind.
Well, and it also gives us an opportunity to talk about the generation skipping tax, which who doesn't love a good discussion about the
I was
GST?
hoping you were going to bring that up.
Well, I think we may save that actually for a topic for another day and not go into it. But yeah, we just have to be aware the estate planning lawyer will bring those concerns into the discussion of how do we make sure that the potential estate tax obligations that may be there, coupled with you mentioned step up in basis and income taxes and trust based taxes. So there's a lot of things to think through and just make sure that you're not again putting those assets at a unnecessary risk of being taxed more than need be.
Absolutely, absolutely. Always talk to an experienced estate planning attorney when you're doing your estate plan. I don't have anything else on that topic. Anything else we want to talk about, Seth?
No, just to summarize kind of your takeaways, look at those 529 accounts because those can be really beneficial from multiple angles and to the estate. Look at the gift exclusion each year and what can you do with that, whether that's funding a trust for the benefit of the grandkids and giving them some sort of now withdrawal rights and those kind of things. And then look at the different types of trusts that may be available to you as part of your comprehensive plan. So that's all I had for today. Thomas, how do folks get in touch with you if they have more questions about tax issues with gifting to grandchildren?
The best way to get in touch with me is by going to viclaw.org and book a call. viclaw.org and book a call. How about you, Seth?
Well, we are here in the heart of Hamilton County up in Noblesville, Indiana. That happens to be our web address, noblesvilleattorney.com. You can find all of our contact information right there.
All right. Well, I appreciate it as always, Seth. We'll talk to everybody later.
See you later, Thomas.